morning, people.
All right, so good morning. Today is election day. So if you haven't gone and voted, go vote. If you'll show me your voter sticker, I'll give you a duck next time. I have to offer that since you can thank your classmate Mason for asking. He's like, since I went and voted this morning, will you give me a duck for voting? And I said yes. So if you'll go vote, I will give you a duck for voting. Is there anybody who's not a US citizen? I'll have to find something else for you to do so that you can get a duck. If you'll go to one of the meetings, I'll tell you what, I'll give you a duck. If you'll go to the AMA meeting or one of the clubs on campus, I'll give you a duck. But the rest of you, if you're American citizens and you're eligible to vote, I'll give you a duck for that. So I've got something that's for anybody who's not a US citizen. Are you part of the Edmondson political family, by the way? No? Okay. James Edmondson is he's a justice on the Oklahoma Supreme Court. His brother Drew Edmondson was Attorney General in the state of Oklahoma for years and years and years. Okay, all right. Oh, so go vote. It's almost over. Hopefully after today or after they finally determine who is going to be the victor in the presidential election, we can take 4 years and not hear about politics every single day of our lives. I'm a former political scientist, so I enjoy it, but I realize that it's exhausting to most people. However, right after the election is over, they start running 4 years from now. Yes.
Do you just want us to like take a picture of us holding our sticker?
You can do that, that's
or-
fine.
Okay.
You can bring the sticker, you can take a picture of holding it, that'll work, any of those things. So if you're not a US citizen, you can go to one of the organizations like AMA has a meeting and here on campus, you can contact the sponsor of that organization, which is Deanie Holmesy, and see when they're doing it, or the finance club or the real estate club or any of those. And just go and take a picture and I will give you credit for that, or if you went and voted. So we were talking last time about the meaning and value of work, and the reason that I told you that we talk about this topic in a marketing ethics course is that we have come to recognize, because marketing is the only fully integrated function of the firm, that you have to engage in not only external marketing, but in internal marketing in an attempt to get employees to do something called living the brand. And I gave you the classic example of living the brand would be Southwest Airlines. Southwest historically has not been the #1 payer of pilots and flight attendants, but they've had far fewer issues with their workforce than some of the other major carriers, which have experienced lots of strikes in terms of pilot strikes and flight attendant strikes over the years and things like that. They're also one of the few airlines that has not gone bankrupt. The margins are very thin in the airline industry, and so a lot of the airlines have gone bankrupt. That's affected lots of their employees in terms of pension plans that were underfunded, and those organizations have had lots of difficulty. But Southwest, because they have this culture where they really, really value their employees, the employees really go above and beyond in living the brand and promoting sort of the Southwest ideology. It's not just about a job for those people. It is about a company that they really enjoy working for. So part of that, how we engage in that, and we engage in employee living the brand management, is by discussions of moral rights in the workplace. And so a previous edition of the textbook had a really interesting, the case study was actually a series of case studies. And let's talk about each of these. So in one instance, they fired a salesman and paid his commission to his sales manager, who was the person who fired him. Is that ethical?
No.
No? You said no awfully quickly. Are you sure it's no?
Well, maybe if there's more information, but with what you've given,
Okay. On the face of it, it sounds bad, doesn't it? What if the commission that was paid was largely generated as a result of the efforts of the sales manager? when you go to work for a company, a lot of them will engage in training, and they don't just generally throw you out there. I mean, in the past, there were sales jobs that were like that. It was like you started and they, gave you your Fuller brushes. There used to be all these people that would go door to door selling Fuller brushes. Vacuum cleaners were sold door to door for years and years and years. My grandmother bought a Rainbow vacuum cleaner. You all have never even heard of this brand. Those were sold door to door. The idea behind the Rainbow was that they were supposed to be really, really good for any people who had allergies, because instead of having a bag that when you took the bag off of the vacuum cleaner to throw it in the trash, it would like release a huge amount of dust and allergens into the air. The Rainbow, you put water into a tank and then it sucked all of the stuff into the water, and then you could just either dump the water outside or down a toilet or something like that. And so that was the big selling point of the Rainbow, is that it was supposed to be really, really good for people who had allergies, to ensure that the home was free of allergens. And while it was vacuuming, part of it was that it also purified the air. It had a method of pulling in from, the ambient air and acting as an air filter as well. So people sold those door to door. Electrolux, for years and years and years, was sold door to door. The vacuum cleaner Electrolux company, they're now sold. You can get them at Home Depot, I think, and Lowe's. But there were all of these jobs, and they didn't provide necessarily a lot of training. One of the things that we've come to realize is that if you want people to be more successful, you have to give them the opportunity to learn about, particularly as products have become far more complex in the modern era, right? Vacuum cleaners are no longer just vacuum cleaners. They don't just vacuum the floor. They have all kinds of attachments and features that have various benefits to them. And so understanding how those features and benefits work and what kinds of people and buyers are going to be attracted to those kinds of features and benefits is really, really critical. And so if the sales manager had done a lot to develop that account, would your answer be different? Well, I think that's something that we need to think about. What about a proportional payment? Maybe should the salesperson have gotten a percentage of the payment that he was entitled to? So it really is, in many instances, context dependent with regard to this first example. What about this one? A mandatory urine analysis for nicotine. UCO does this now. I just got my health benefits for the next calendar year. So although we run on an academic year, benefits and things like that run on a calendar year. So in January, we start over with our health benefits and things like that. One of the things that UCO does is if you are a user of tobacco, they charge you a premium for your health insurance benefits. Should they be able to do that? Yes.
There's research that's out, at least for cigarettes, that they're unhealthy for your lifestyle. And so engaging in an unhealthy lifestyle and expecting to pay the same premium as someone that is engaging in a healthy lifestyle probably isn't.
Where do you draw the line? There are lots of things that are unhealthy. Alcohol consumption is enormous. In fact, they have now determined that probably there is no safe level of drinking. And I say, I'm a lawyer. If you've gone to law school, you drink, right? Until you go to whiskey school. That's generally, I mean, people who didn't drink. We had this student in my class. She was the daughter of a Southern Baptist minister and never drank. After the first set of exams, I went to a bar with everybody else, and there she was, drinking. She decided she was gonna take it up at that point. And there's now research that suggests they used to say maybe a glass of wine, a red wine, was healthy for your heart. There may be no safe level of alcohol consumption at this point, is what they're saying. Some of the research suggests that there is no. So are we gonna start penalizing people who drink? You can get a duck, by the way.
That's what I was gonna say, because it's like, how do you draw the line with that? With, I mean, alcohol, like you said, is considered bad, nicotine's considered bad, but employers don't really have the right to like sit there and say, you can't do that. Now, maybe if their like whole thing is on health, like, I don't know, like some yoga type thing or something like that, they could have some more grounding. But like UCO, I don't see how it would really be reasonable for them to, what would you say, the premium thing if you are using tobacco? Like,
Now, this company, it was actually a healthcare insurance, they provided health insurance. The company that did this, the first one that came up with this, and they fired people if you smoked. They weren't charging you more for your premium, they fired you. I mean, the owner's idea was that smoking was just bad for you, it was morally offensive to him. And so he gave you 6 months, when he decided to do it, he gave employees 6 months. It was very controversial to quit. And then he went so far, I think several years later, he went so far as to say, if your spouse didn't quit, they would fire you. Because you'll still test, if there's somebody smoking in the house with you, you'll probably test positive for nicotine.
so then how do
exposure.
you draw that line with privacy and things like that? You like tell your spouse to stop smoking? Like, that's just,
Do you have privacy anymore? Do we, I mean, according to the Supreme Court, by the way, we had this belief in privacy, which is expounded in a case. So the first case that we find that discusses privacy, if you look for the word privacy in the Bill of Rights, which are the first 10 amendments to the United States Constitution, the word privacy is not found in there. In a case called Griswold versus Connecticut, 1963, the Supreme Court, in an opinion written by Justice Douglas, I believe, William O. Douglas, said that although the word privacy was not found in the Constitution, you could get it in the penumbras and emanations of the document. So a penumbra is borrowing a term from the physical sciences. When you have an eclipse, let's say a solar eclipse, what you see is, because the moon is so much closer to Earth than the sun, it appears that during the eclipse that the moon blocks out the sun, and there's this shadow area, which is the penumbra of the eclipse that you see. If you've seen pictures of this, I'm sure. There's this kind of shadowy area. And so the penumbra and emanations of the Constitution, where do these penumbra and emanations suggest that we have a right to privacy? Well, in the First Amendment contains 5 substantive due process rights: speech, press, religion, petition of government for redress of grievances, and assembly. And if we have this freedom of consciousness of mind, the justice says that this implies a level of privacy. The Third Amendment to the United States Constitution, nobody even remembers what the Third Amendment is. It deals with the quartering of soldiers during wartime. The British were famous for doing this. They would send soldiers to the United States colony, and the soldiers could just go in and invade your farm and take over and quarter themselves there under British law. That was particularly offensive to the colonists. And so they put this in the Bill of Rights, that you couldn't quarter soldiers in private homes during peace times, and in times of war, only in a manner prescribed by the United States Constitution. And Justice Douglas says, well, that implies a right of privacy, right? That the government can't just come in and start going through your house and quartering themselves there. The Fourth Amendment to the United States Constitution, which prohibits unreasonable searches and seizures, implies a right of privacy. The Fifth Amendment, which prohibits you from being compelled to be a witness against yourself and provides for due process of law. So the first of 2 due process clauses is found in the Fifth Amendment to the United States Constitution. The Sixth Amendment's right to counsel applies a right to privacy according to the court. And then the 10th Amendment, which says that these rights that are enumerated in the Bill of Rights are not exhaustive, that there may be more, right? This all implies that we have a right to privacy. The progeny of Griswold is a case called Roe versus Wade, which is a 1973 case, which established a woman's right to have an abortion, which was overturned recently, right? And so the court has said in that opinion, in the Dobbs decision, they have said that substantive due process are up for grabs, perhaps. So we used to talk about procedural due process in law school, PDP, and substantive due process. Substantive due process are those rights which we consider so fundamental as to be part of what is necessary for an ordered and Republican form of government, right? And so, do we have a right to privacy? The court has basically said with Dobbs, no, you don't. You don't have a right to privacy. At least not a constitutional right to privacy anymore. Even if we had a constitutional right to privacy, is there any practical way of getting, I mean, the average person is photographed or recorded thousands of times a day now. Every time you walk past an ATM machine, every time you walk into a gas station, a bank, most businesses now, the Walmart parking lot. We have cameras on campus. Do you have a right to privacy anymore? What about with regard to this firing of employees for nicotine? What about a sedentary lifestyle? That's just about as bad as smoking, isn't it? Sitting around? Should we ensure that people are put on health programs? Could their employers insist on that? When I was married, my spouse, Robin, went to work for Chesapeake. And at that time, Chesapeake had a gym on campus and they were very healthy. It was a very young company. And there was a culture there of not taking the elevator. They had elevators in all their buildings because it's required by the ADA. If you have a multi-story building and new build, right, that you have an elevator. And so they had elevators, but the culture was that you didn't use them. You took the stairs everywhere. And that was part of their way. It wasn't a rule, but they just had this culture of you use the stairs so that you get exercise, so that you're not, even if you're not taking advantage of the gym, you're not just engaging in a sedentary lifestyle. One of the things that has happened in the United States is as a result of the fact that more and more people, fewer and fewer people are engaged in jobs that require physical labor, and more of us are sitting down, the amount of heart disease has increased. We now have children, young people who are experiencing levels of heart disease that we never had before. Why? They don't do anything. Everything that you want to do is on that device in front of you or on your phone, right? So should we be able to tell employees, if you want health insurance, you have to engage in a workout routine? Pick something? What about firing an employee who's considering having an abortion? Well, again, you used to have a constitutional right, but the fact that you have a constitutional right doesn't prevent private actors from limiting what you can do. So you have, under the First Amendment to the United States Constitution, free speech, right? Freedom of speech, press, religion, petition of government for redress of grievances, and assembly. Those are the 5 substantive rights. Can your employer limit what you say? Absolutely. At work. Can you be fired for what you say at work? Absolutely. Unless you go to work for like a state agency, and then you have First Amendment rights. As a college professor, I have First Amendment rights. But in private employment, can they, tell you that you can't say certain things at work? Yeah. Absolutely. Before the Affordable Care Act, this was a big deal. I remember, you all are too young to remember this, but I actually remember a time before HIV/AIDS. You all don't remember. I mean, just statistically, you cannot remember a time before HIV/AIDS, but I do remember a time before HIV/AIDS. And in fact, I remember the first cases of it. We lived in Santa Fe, grew up in Santa Fe, New Mexico. My mother owned a real estate company, and as part of that real estate company, she owned a bunch of rental property. And the second person in New Mexico to die, they didn't call it HIV/AIDS at the time, they called it GRID, gay-related immune deficiency, is what they called it at the time, died. He was a tenant of my mother, right? And I remember that, and it had a profound impact. At that time, it was like, you all you can relate to this because you went through COVID. It was really, really hard to get treatment for these people because they didn't know if it was an airborne pathogen. And so if the alarms went off, they would respond on the first time. When these people would go into the hospital, they would not respond to a second code red in the hospitals because they were so terrified of the illness. And so it was a huge deal. Companies, as a result of the increased cost of insuring people with HIV, tried to deny healthcare benefits to employees. Now, you cannot do that under the Affordable Care Act, which is an interesting point because when we talk about rights, we'll talk about 3 different types of rights, right? So you can't do that. But should you have been able to do that in the past? Deny benefits? If you've got one person who's like costing the company all this money and benefits, should you be able to deny that individual? For those were what were called pre-existing conditions. And it used to be that if you went out and got private insurance, if you couldn't get insurance through your employer, they did screening. If you got private insurance, they would send somebody out and they would take a blood test. And if you had HIV/AIDS, it was excluded from your coverage. They can no longer do that with the Affordable Care Act. But should they have been able to? You can justify it under a utilitarian theory of ethics, can't you? It's those people just cost more. Sorry, you got to sacrifice the one for the many. On the other hand, the whole purpose of insurance is to do what? Spread risk. That's the purpose of insurance. It's to provide, a spreading of risk. Right? You were going to say something?
Couldn't they have just covered a certain amount and capped it at that? So
They did do that, right? And for years, that's another thing before the Affordable Care Act, they had lifetime caps on it. You can get a duck. That is basically what dental insurance is not really insurance. It's a dental supplement, because if you have to get like a full mouth full of implants or things like that, it doesn't cover that. I mean, it's not going to cover that. It covers cleanings and things like that and basic dental, but it doesn't. There's a cap on it usually, and it's a fairly low amount. If it's a generous plan, it'll cover something like $5,000. Well, $5,000 doesn't cover a whole lot of dental work if you've ever had any kind of dental work done. Right? I've been fortunate. I haven't had a lot, but I've had friends who have had it. Yeah.
So then how did they kind of excuse doing that to people with HIV? But then like, I think of employees with cancer, diabetes and things like that, that are similar in like price-ish, depending on,
Right.
you know, the extent of diabetes and stuff. So how did they end up kind of excusing, oh, well, we're not gonna pay for this HIV, you know, employee, but we'll pay for you, we'll pay
Right.
for these guys?
Exactly, yeah. The truth of the matter is that one of the things before the Affordable Care Act and with genetic testing, one of the reasons that I never went and got the 23andMe, how many of you have done that? Is now you've given your information to a third party and who the hell knows what they're gonna do with that information, right? But it could, I mean, the thing that 23andMe will or has the potential of detecting is whether or not you are predisposed to certain things. And in theory, in the past, before, they could have started saying, you know, if you show a predisposition to cancer, we're not going to cover that. If you show a predisposition to heart disease, we're going to exclude coverage for that. They could. I mean, it was just that HIV, there were two things that really, I think, impacted HIV. One was a stigma. And in the 1980s, when HIV was really a huge thing, there was a stigma associated with it, and there was a feeling among the American public that these people deserved it. They got it because of their reckless behavior, right? I'm not making a moral judgment. I'm just telling you what the sentiment was at the time, that there was something qualitatively different between somebody who was HIV positive and somebody who got cancer, because cancer was something that, you know, may or may not. Now, it turns out that a lot of cancers we can control. Smoking, right? There's a direct link to many cancers and smoking. Eating certain types of foods increase your risk of cancer. I mean, if you are eating, and I hate to say this because I love red meat. I grew up on a cattle ranch. If you're eating red meat and bacon 3 meals a day, there's a lot of evidence to suggest that it is linked to higher levels of, you know, stomach, colon, rectal cancer, things like that.
What happens?
You can get a duck, by the way.
What happens if you don't have like HIV and then you start working there and like you already have your insurance and then you get it? Like, do they just cut that?
Okay, so what would happen is that would not be a pre-existing condition and you would have been covered until what they would do is when they renew the insurance, right? And then they would, like, we renew our insurance every single year. I have to go in and basically sign up for benefits every single year. And so what they would do is they would just cut at that point. So you'd be covered through the year, but after that, you might not have coverage. Can't do it anymore, right? That's what we call, so we've talked about constitutional rights. We've also got statutory rights, right? As a result of the Affordable Care Act, they can no longer do this. Now, it doesn't mean that it won't be expensive for you to get insurance on the private market, but they cannot deny you insurance. Employee emails. You all have grown up in an era in which I'm sure you know that you don't have an expectation of privacy in your emails. If you log on to the D2L system, it says you have no expectation of privacy. If you don't want that, log off now. And of course, it's a contract of adhesion because you don't have a choice. If you are going to participate in the educational process here at UCO, you're going to have to use D2L. It's the way we record and maintain our grades now. It can't opt out. What does that mean in terms of your, well, think about what you're sending. This actually involves a very famous case called Connick versus Myers. There's a very famous sort of jazz musician, actor. You may have heard of him, maybe not because you all are fairly young, named Harry Connick Jr. Anybody heard of him? Okay, so one person has heard of Harry Connick Jr. He played on Will and Grace, for example, as Grace's love interest in several seasons. He's played in a number of movies. He's from New Orleans. His father, Harry Connick Sr., is a very famous attorney. He was the district attorney for Orleans Parish for something like 60 years. I mean, an enormously long period of time. Harry Connick Jr.'s family is very, very famous in the New Orleans area. I think his mother is also an attorney, but I may be wrong on that. I'll look. But his father was district attorney of Orleans Parish. He had an employee who was very disgruntled with the management of the office. He'd been in power for a long period of time, and she started writing unflattering emails and sending them out to her colleagues, and he fired her. And she claimed that she had a First Amendment right to expression of free speech. And it was a big case. Do you have the right to expression of free speech? I think you all recognize that with regard to your employees, email system, no, you don't. Now, the interesting part in hers is because she was a public employee, public employees do have an expectation of being able to have free speech. But what they focused on in her case was the behavior and the outcomes, that she was creating a hostile work environment, right? And there are limits to free speech. Even though the First Amendment begins with the words, Congress shall make no law, right? And when we talk about this, is no law, is that an absolute term or is it an equivocal term?
Sounds pretty absolute.
Yeah, you can get a duck. That's right. It's an absolute term, right? And the court has never said that no means no. No may mean sometimes. You don't have an absolute right to freedom of speech. What are some of the limits of freedom of speech? Well, in the classic case, you can't shout fire in a crowded theater. In Chaplansky versus New Hampshire, the court says you can't create a fighting situation, a situation in which you're likely to incite a riot. Those are called fighting words. So Chaplinsky was passing out, he was a pamphleteer, he was a Jehovah's Witness, he was passing out pamphlets and tracts in a city in New Hampshire. He was upsetting the local citizenry by his tracts. The police showed up and said, you got to stop doing this. And he called the police officer a damn fascist and racketeer. And they charged him, and it went all the way to the Supreme Court. And they said, look, that's likely, getting in somebody's face and calling them these words is likely to incite violence. And so fighting words are not protected under the First Amendment to the United States Constitution. Shouting fire in a crowded theater is not protected because it's likely to create a knee-jerk reaction that will lead to bad results. Yeah.
And defamation too. 'Cause
Yes,
like-
that's correct. So libel and slander is another one. You can't just say whatever you, now, in the United States, unlike in other countries, it's very difficult to get judgments on that, right? Particularly if you're saying it about a public person. If they have taken on any kind of public role, they have assumed the risk that people are going to say unflattering things about them. And you've also got several affirmative defenses to the defamation, which is truth is a defense, right? If somebody says about an individual that they're morally reprehensible, they're physically repulsive, they're intellectually, challenged, and not even interesting enough to make you sick, is any of that defamation? Those are all matters of opinion, right? Those are all opinion. Now, if you say someone is a known felon, does that change it? Yes, because that is an objective fact that can be ascertained, right? Felony conviction is something that you can ascertain. And so if it's true, they have an affirmative defense. But if you're a public figure, it's very difficult to prove defamation of character. Right? The courts take a very, very dim view of that. So employee emails and free speech rights. Pre-employment psychological testing, this is one of my favorites. So they gave employees a test that asked questions like, answer the following questions, true or false, or or yes or no. I believe there is only one true God. I believe that that marriage is between a man and a woman. I believe that there's one true religion. I wish I weren't bothered by feelings of sex so often. I really love this one. I have had no difficulty starting or holding my urine. Should you be able to ask those questions on a pre-employment psychological test? That test is called the MMPI, and it's used by a lot. It's supposed to tell, they're not really looking at individual answers. They're looking at whether or not you have stability within answers, right? It's not really about, but should you be able to use the MMPI?
I guess it would depend if it directly correlates to your work or something that, like, say if you were an astronaut,
Okay,
you have trouble with, like if you have a pre-existing condition, like what you were
Okay.
talking about before, like it should directly correlate to your work if it has nothing to do with your job or your position.
So,
then it should
the MMPI is used a lot. It's used particularly, I believe, my father is a retired FBI agent, a retired special agent in charge. And I believe that the FBI insisted that their agents go through MMPI psychoanalysis before they're allowed. Is that a legitimate thing to do? Maybe. You're giving them a gun, knowing whether or not somebody is, sort of fundamentally stable is perhaps an important part of the job. Is it a necessary characteristic? What about denying positions to females that may be detrimental to pregnancy?
It made me think of the motherhood penalty, which is kind of one of those like phenomenons. We just talked about it in one of my other classes where mothers literally are always like kind of given like the short end of the stick when it comes to pregnancy. Women in general, like if you're like of birthing age or whatever, I forgot how they define it or whatever, but you're like way less likely to get hired for a position for like even an older woman or a man because
so-
of that.
Yeah, law firms, and they sort of have an objective criterion. It's well known in the legal community that if you want to go into a law firm, right, that there are two tracks if you are a female. Historically, there's the mommy track and there's the partner track. And if you take the mommy track, you're probably never going to be, you're going to be an associate, if they'll even hire you. Historically, this is changing, right? So how many hours are in a work year? Well, how many weeks are in a year? There are 52. If you multiply 52 times what's a work week? How many hours are in a work week? 40. 40, right? If you multiply 52 times 40, you get 2080, right? Is that correct? Did I do my math correctly? You take 80 out for vacation. What are you left with? Actual work, 2,000 hours. When I graduated from law school, law firms in Oklahoma City wanted you to bill 1,900 hours a year. That leaves 100 hours left over. In order to bill 1,900 hours, how many hours are you having to work in a week? It's not 40. It's far more than 40. In order to bill 1,900, and some law firms want more than that. One of my friends went to work for a law firm where they were expecting their associates to bill 2,300 hours a year. If you're billing 1,900 hours a year, you're probably working 70 to 80 hours a week. If you have children, the likelihood, particularly if they are young, of you being able to bill 1,900 hours is almost non-existent. Right? And so, yeah, this is what we call a disparate impact phenomenon. It appears to be an objective, you either met the number of hours that we want you to bill or you didn't, but it disproportionately affects one group of people more than others. And so, this case actually was a case, I believe it was related to Kerr-McGee. Kerr-McGee actually used to have a facility not very far from here up in Crescent on the Cimarron River called the Cimarron facility, where they were manufacturing radioactive pellets for nuclear reactors. And they wouldn't allow, there were very high-risk jobs, and those high-risk jobs would affect women. And there's a movie about this that came about, not about the denial of positions to females, but it was called Silkwood. It stars Meryl Streep and Cher, and they play Karen Silkwood, and in the movie they call her Dolly, but her real name was in real life was Sherry Ellis, and they would have to go by a Geiger counter and test every day to make sure that they had lower levels or had safe levels of radioactivity. Well, as a result of the fact that these levels of activity could affect pregnancy, they were limiting the number of women that they would allow, or women that were of childbearing years, to positions in those kinds of jobs. Should they be able to do that, given the risk?
I
Yes.
feel like that kind of makes sense because at the end of the day, like if they were to be harmed and they were pregnant, then wouldn't you be mad as the woman and be like, you put me in this environment knowing that it could harm me and my child?
Well, and you could have a workers' comp issue, right, with it. B, yes, you could see the children coming back and suing the employer ex post facto. You can get a duck, by the way. I mean, yeah, there are lots of concerns. I think lots of people are just like, that's just morally offensive though, right? I mean, like, you shouldn't be able to do that. What's the solution? The solution is to have a safe working environment. I mean, people work in nuclear facilities and don't get irradiated all the time. Like, provide safety equipment. Like, don't irradiate your employee. That's the solution.
Because then you're just harming everyone. So then,
Right.
like, if men, like, you don't know that could have an effect on their sperm.
Right.
So,
That's one of the, yes, I mean, historically, one of the things that we have come to realize is that a lot of the things that we thought just affected pregnancy from a female perspective, actually exposure to chemicals and things like that can also impact, male viability.
Like Agent Orange was the big one. when
So it can lead to, problems later on. Yeah.
I was just gonna say that the company should at least inform the woman that it could be dangerous for pregnancies before
I think everybody
or
knew.
going forward
Yeah,
with any
I think
employment.
everybody knew that, right? I mean, the question is, could you deny, is it a BFOQ, is it a bona fide occupational qualification that you could deny women these jobs as a result of the fact that it could be detrimental to fetal development? And I think the legal response generally is, I mean, historically, again, we shouldn't be too quick to think that this kinds of things still don't happen in the world today. My administrative assistant in Guthrie remembers a time where if you wanted to get a credit card, I mean, she's old enough that she remembers that when she wanted to get a credit card, she had to have her husband co-sign with her. If you were married, you had to have your husband approve and co-sign to get a credit card. That wasn't that many years ago. That we had those sort of paternalistic attitudes, and should we? Again, my response to this would be, provide safe working conditions. Right? Like, that's the solution, is provide safety and working, yeah.
So like say a woman did take this job like knowingly with the risks out front, would she be able to take action in the case that, you know, she did get irradiated?
So you can have a duck. That's a good question, right? Can you waive could you waive your rights, right? We do that all the time. And I think the answer is that maybe you could waive the rights for you, but when your child is born, can you waive future generations' rights? And I think the answer to that is no. And so these companies like Kerr-McGee and I think it was Kerr-McGee that was the case study. I may be wrong on that, and I'll double check. But again, there was this movie Karen Silkwood. You all should go, because it takes place in Oklahoma. You can find the spot where Karen Silkwood drove her car off the road, which is Portland Avenue, is the avenue that runs up into Crescent. Can you waive rights for your child? And I don't think that the answer to that is that you can't, right? We just, that just seems abhorrent. You can't really waive rights for other people. You can't assert rights, generally speaking, for other people, and you can't waive them. Now, there are exceptions to that, right? Parents can obviously sign, when you go get vaccinations, the doctor is going to ask you to sign a waiver that says that you recognize that vaccines may have adverse reactions. Kids can't sign them on their own behalf, and so parents do waive them. But I'm not sure that as a public policy matter that you could waive that kind of right to the child having a future interest in litigation as a result. So, good question. Yeah.
So looking at it, it seems like the motivating part is just cost saving for the company. If like the solution is, hey, make it a safe environment, and the liability, you can't limit it by just them agreeing to it.
Right.
It seems to be just, let's avoid the whole thing altogether.
The other thing that I will tell you that they did in this case is they said if women would go get sterilized, they could have the job.
And so it's just kind of, okay, we recognize that what the situation we're putting them in isn't safe. So then either just totally avoid it by saying, by limiting them, or go get sterilized, because it's the easiest way out, I guess. Is that the motivating thing behind it, is just kind of cost saving or trying
Yes,
to.
yes. But my response is like provide safe work.
Yeah.
Now, and get a duck. There comes a point at which there is some risk inherent in anything that we do, right? There's a risk every day that you got up and you get in the shower. How much water does it take to drown in, for an adult to drown in? It's like an inch. Literally, if you fell and slipped in your bathtub, if you're taking a shower, fell, slipped in your bathtub, there were an inch of water, I think you can drown in that. I mean, life is inherently risky. And so I think that, we have to, there's obviously a point at which you can't eliminate all risk. So there's still some risk. And at that point, then I think you need to say, well, we've taken all of the known precautions. We can't deny this is not necessarily a BFOQ, right? Because with regard, what the courts generally look at with regard to BFOQs, modified occupational qualifications, is not whether or not you could do it better, but whether or not you can perform the essential functions of the job. Not whether or not, and Southwest Airlines, Southwest is my example of living the brand. They're also an example of moral failure in that in their early age, they wouldn't hire, and this was true of lots of airlines. The airlines would not hire men to be flight attendants. In the early days of airline travel, they were called stewardesses. That has a negative connotation now. They're now called flight attendants, but they wouldn't hire males to be flight attendants. And Southwest was one of the biggest ones that would say this. And they said, the reason we won't hire flight attendants is because their business model was basically flying Texas oil men around various places in Texas, from Dallas to Austin to like Amarillo and Lubbock and places like that in Houston. That was their model. And they said, our businessmen want to feel the love, and they won't feel the love if you have a male flight attendant. And the court looked at that and said, well, and they argued that this was a bona fide occupational qualification. And the court looks at that and says, is it a bona fide occupational qualification? Well, no, because flight attendants, while they may spend most of their time bringing you a drink and giving you peanuts, they are required by the FAA as part of necessary crew for safety. That's the purpose. That's the main purpose. Can men do that job equally as well as women? Yes, right? The main purpose of a flight attendant is to be able to open the doors in case of an emergency, launch the ramps, and direct people to a safe exit. And so when you say, in these cases where you're saying these jobs present an inherent risk to a population, is that part of the essential function? Can somebody still do the essential functions of the job? That generally tends to be the test. And if they can still perform the essential functions of the job, well, then, courts are very hesitant to say that that's a BFOQ. I'll give you an example of something that does have a disparate impact that has been upheld. So if you want to be a prison guard in a male prison facility in Oklahoma, you have to be able to drag a 250-pound dummy across a gym floor. That has a disparate impact on female applicants. Right? There are far fewer female applicants that can drag a dummy across a gym floor than there are male applicants. Is that a legitimate BFOQ? The courts have said yes, because there's a close connection. There's a nexus between what you are doing. First of all, you're not a priori excluding a category of people. And there's a close nexus between the essential functions of the job and the task that you're asking them to do. So, all good, really good questions. So work is controlled by others, which is one of the reasons why, as marketers, we're interested in this idea of rights. Because if we want to get the most out of our employees and we want to encourage them to live the brand, we have to recognize that this factor means that they are vulnerable. So what kind of rights are we talking about? Well, there are three senses that we can talk about in terms of rights. We can talk about legal rights. Those are found in either constitutional rights, and some of these constitutional rights do apply. So you don't have a First Amendment right against your employer, but you do have certain constitutional rights, according to case law, that are things like you can't be discriminated against on the basis of race, creed, color, religion, gender, disability, age, things like that. Those are constitutionally protected rights or statutorily protected rights. So we have constitutional rights. We have positive rights. These are established not constitutionally, but by legislative act. So that's positive law. Those are enactments of state legislatures, Congress, local city governments, city councils, things like that. So we have these contractual rights. And then we have common law rights. These are court adjudicated rights, where the court says, for example, in tort cases, a lot of the rights that we enjoy as employees to be free from unreasonable risks in the workplace are positive law. But there are also some common law rights that have occurred over time as workers have gotten injured, right? If we go back to the beginning of the 20th century, we had lots of people working in very unsafe conditions in textile mills in the beginning of the Industrial Revolution. And workers basically, if you got injured on the job, sucked to be you. you got that day's wages and they sent you home. If you lost a finger or an arm or something like that in these huge textile or, assembly line type jobs, well, it sucks to be you. And the common law was that basically it was employment at will. We've now seen through court interpretation, those ideas being limited, that you can't just, expect people to work. Now, a lot of those are, again, statutorily imposed or through positive law. So we have legal rights, and those are interesting because one of the things that we hear is that, well, the law is an acceptable moral minimum. It's not necessarily, but it is a consideration that we have to think about. Then we have contractual rights. These are the things that you bargain for as an employee that are important rights. What are some of the contractual rights? Well, it's things like benefits. Generally speaking, in the past, employers were not required to provide you with benefits. Now, why did they do that? Well, it's to differentiate them from other employers and make it a place that people wanted so that they could attract workers. If we take the idea that you want productive employees who engage in living the brand, right? Well, how do you do that? Well, it's by providing them with an attractive package that allows you to be competitive and differentiate your company from other companies in the market that are out there. So it's things like health insurance, dental, vision, right? Time off kinds of things. There are employers that are now moving to unlimited time off as a benefit to working there. We don't tell you you've only got 2 weeks. Historically speaking, what did the American workforce look like? Well, you had a week of sick leave and 2 weeks of vacation if you went to work in corporate America. It's one of the reasons why I left corporate America. When I went to work in the private sector and I became an executive vice president, my boss said, "No, we give you 2 weeks of vacation," but none of the executives ever take it. We expect you to be here. And when I asked to take some vacation for my brother's wedding, he told me that I couldn't have it off. And I'm like, well, just so you know, I'm also going to give you my resignation now because I'm going into a doctoral program. That is an unacceptable answer. And I'm like, well, that's the answer you're going to get, right? Sorry. We have this thing called the 13th Amendment, which prohibits involuntary servitude. Jeff. So, 2 weeks of vacation. Now we've got companies that are saying, and one of my friends actually, he works in a place where they have 2 types of workforce. They have govies, that's what they call them there, for the federal government. And those are federal employees. And then there are contractors. And one of the contract companies they have unlimited time off. Their employees have unlimited time off. Now, this sounds good from the employee perspective, right? You've got unlimited time off. But if they never give you enough time to take it, is that really a benefit? And what's the reason that they're doing it? Because if they say we don't give you time off, when you leave, they don't have to pay you out for it. Right? If we say you get 2 weeks a year or whatever, and you can accrue so much, and then you leave, you can, have to pay those people out for it. But if you just say, take time when you want it. It's up to you and your supervisor to determine whether or not. Well, I think it's a horrible idea from a couple of perspectives. One is that most employees who are good employees won't take it and they'll get burned out. Whereas if you have a set time and you lose it, people then have a tendency to take it, right? If you say, we give you 2 weeks and you can accrue up to 4, but after that you lose it, most people will choose to take it. And you need time off. from work. Or at least most of us do. I know several people who just seem to live to work. Not me. I work to live. But, so contractual rights, things that we can contract for, time off, benefits. What are some of the other things that we could have in terms that are less tangible rights that you might have in the workplace? Well, one of the things, for example, that 3M is famous for is actually sharing with their employees who invent things. If you invent something at 3M, they get the patent in it, but they actually provide a fairly benefit-rich sharing program to encourage. And scientists at 3M historically have been given a lot of time to work on non-specifically assigned projects. It's one of the ways that they came up with, as I understand it, Post-its. What is 3M known for? They're known for adhesives. That's what 3M has largely been known for. They're known for other things as well, but one of the things that they're known for is adhesives. Well, one of their scientists came up with an adhesive that wasn't terribly adhesive, but it's just adhesive enough that you can stick it, a piece of paper, to something else and pull it off cleanly. It was an accidental invention. And they provide incentives for that by giving the inventors of those certain reward structures under that. And that's a contractual right that these people enjoy. We have similar rights here at UCO. Generally speaking, intellectual property that is developed within the scope of your employment belongs to your employer. But as a college professor, generally speaking, with regard to things like copyright, I own the copyright in my stuff unless I agree otherwise with the employer to give up the copyright. So for online courses, we specifically engage in a contract which assigns our copyrights to the university. But all of the other stuff that I produce, for the most part, I retain. Whereas other employers can say, if you produce it during the course of the job, what are some of the things, for example, like, now it's not worth anything because as much as I would like to believe that, I have thousands of YouTube fans out there watching my YouTube channel, the counts on my channel suggest that nobody really watches this stuff. You all don't even watch this stuff. I've got very few counts. The counts that I have numbers on are counts where are videos that I've done where I'm doing something that is useful, I guess. So for example, I had a Dodge Ram 3500 until last week, which I sold. And it's got these huge mirrors because it's a dually. So the mirrors extend out because you're hauling stuff, and they get hit frequently because people go by and they're not paying attention in neighborhoods and stuff like that. And the mirrors are out and they'll hit them. Well, the first one that got knocked off, I took it to the Dodge dealer and it was like $1,000 to replace that mirror for them to do it. It had happened in upstate New York when I was visiting my brother. It's like, that is crazy ridiculous to replace a mirror. So I figured out how to replace the mirror myself, and I made a video the next time it happened of me replacing the mirror. And that's got like thousands of hits of me, disassembling the Dodge Ram pickup door and putting this mirror on, because you have to take the whole door panel apart and put the mirror back on and then reconnect it because it's got all this electronic stuff in it. It's got a puddle light, right? Those are the ones that I have. So, at lots of places, if I made this video, it would belong to the company that I made it for, right? So those are contractual rights. What we're interested in this class are moral rights. What are the things that go beyond these sort of contractual? And there are moral implications to these rights, like Fair Labor Standards Act, right? What is the minimum wage? The Occupational Safety and Health Act, which is administered by the Occupational Safety and Health Administration. The Family Medical Leave Act, the Employee Retirement and Income Security Act, right? These are all things, and they have moral import. And so they're not necessarily just these bright lines, but we're really interested in the moral implication of these. And are there rights that go beyond these sort of contractual legal rights to being moral rights? And I think that there are rights that we have to consider that go beyond. One of them that they talk a lot about is right to work. Now, when we talk about right to work, there are various issues involved, and one of these issues has a great deal of moral import, and it's called the right to work laws. And these were very popular. They passed in a lot of places in the 1990s and early parts of the 2000s. Oklahoma had a right to work law. I don't know why we had it, because it was not really a big issue, but people overwhelmingly went and voted for them, because I don't know that they understood what they were voting for. And even if they did, I think they had a negative image of what the act or the activity that it was meant to regulate or limit was occurring. So right to work laws generally address not an individual's right to have a job, but their right to not be forced to participate in what's called collective bargaining. This is unionization. So states that don't have right to work laws, where they have heavy union organizations and representation, the union can require, if you are going to go into that industry, that you have to at least pay the portion of the union dues that cover the collective bargaining activities that the union engages in. And employees, or some employees, hate these. Why? Well, because it's money coming out of your paycheck that goes to the union. And you don't have a choice. You have to participate unless your state has a right to work law. Now in Oklahoma, we passed this law, and basically what it says is you can't be forced to join a union. Well, this creates for unions what's called a free rider issue. What's a free rider issue? A free rider issue is what happened to me the entire time I was in undergraduate. So when I was in undergraduate school, we have all of these things where we want you to engage in, learning activities with your peers. And we particularly love these in the College of Business. And as a student, I hated them. As a professor, I like them, because if I can get 5 group projects instead of 29 group projects, that creates less work for me, ultimately, right? I'm now grading 29 people, but only having to grade 5 things. As a student, I hated them. Why? Everybody knew that I was going to go to law school. That was my plan. I mean, I made that very, very clear that I was going to law school. And what did that mean? Well, the way you get into law school is you have to do 2 things, right? You have to have, at the time I went, there were something like 15 applicants for every slot in law school. That's no longer true. Law schools are hurting for enrollment, like lots of places are. And so there are very few applicants. But at the time I went, highly competitive, right? So the way you got into law school was you made sure you did really, really well on 2 things. Your undergraduate GPA and the LSAT, also called the LSAT. When I went to law school, you could only take the LSAT 1 time. That was it. You could take it more than once if you wanted to, but no law school counted anything other than your first attempt. So it was not like the ACT or the SAT. It was truly a high stakes exam. That was it. And the way they determined whether or not you got into law school was they multiplied your undergraduate GPA by 12. They added 100 points to that number, and then they combined it with your LSAT score, which was on a scale of 180, and that gave you an index. And they just went down the row. So they would just list everybody in a line, and they would say, like when I went to law school, there were 100 slots, and the top 100 got it. And the only way your essays and things like that you wrote to get into law school mattered is if you were statistically in this bubble where there were lots of people who had the same composite index and it was the last slot. And then they would turn to the essays to read to determine who got that last slot or the last couple of slots. You didn't want to be that, right? So what happened to me was because everybody knew I wanted to go to law school and I was really determined to get a 4.0 grade point average to get into law school. In all of the group projects, who do you think ended up doing all the group projects? Me, because there was an incentive for my partners to free ride. Because they knew I was not gonna let it fail. I was going to do the work. Unions have the same problem. If they can't insist that people pay, at least for the portion of the dues that go towards collective bargaining, people won't. But they'll take advantage of the union's collective bargaining abilities. Historically, the way workers had power against very powerful economic forces like major corporations was by banding together. Because one little employee doesn't have a lot of power. But if you go on strike and you have the entire factory going out, well, now you've got some power, right? So right to work laws said, well, you don't have to join the union. Well, how does the union then compete? Well, in places like Oklahoma, what does it meant? Well, it's meant that we have no union for the most part. There are very few unionized workplaces in the state of Oklahoma. What are some of them? Police departments, fire departments. You know, there's a few industries that have unionization, but not many. Right? That's what the right to work law is. I'm out of time, so we'll pick up with this and we will talk about employee responsibilities next time as well. And I will see you guys in a week. You have until midnight tonight to finish the second exam, and then I will start grading. So be sure and get those in. If you got ducks, come see me. Let me take a picture of this. I'll stop the